number 191586 and number 191640, Project Veritas Action Fund versus Rachel Splain Rollins, and number 191629, K. Eric Martin et al. Versus Rachel Splain Rollins.
We just walked out. We just walked out of this federal courthouse. It was a packed courtroom, appellate court. ACLU was with us. How you feeling after what just happened?
Feeling really good. This is a historical challenge to a complete ban on news gathering occurring in public. And it's unimaginable that Massachusetts walks away from this with the law intact.
So what were you asking the appeals court to do today in that courtroom?
We want the law completely invalidated. In a free society, citizens should be allowed to go into public spaces and be able to get information and report on that to the American people. That's what you do day in, day out, throughout the year.
Massachusetts makes a mockery of the most effective form of news gathering, undercover journalism, by denying citizens the right to be able to go out into public and to be able to gather information in the most effective way possible, that is, secret audio recording.
What do you mean by public?
I mean a place in particular where there's no reasonable expectation of privacy. It brings me to the truly exceptional nature of Section 99.
So just so I get it straight, with the idea that everybody in this courtroom right now would have a First Amendment right to record these proceedings?
Yes.
That's your position?
Yes.
Do you have a narrower position?
Massachusetts is the only state in trying to protect privacy that instead of fashioning a tight, narrow, precise law, drafted something that was broad and clumsy and utterly made it illegal to be able to engage in news gathering. Think of it, if you cross the law and recorded it illegally in Massachusetts on the Boston Common, you're going to prison for 5 years. You're having attorney's fees awarded against you. You want to send a strong signal to undercover journalists not to record? This is the law that does that.
A meeting with a confidential informant, if it's done in public, what's wrong with that being recorded? If the police officer wants that meeting to be truly confidential, the police officer can control where the meeting is held. Easy enough to hold it in private.
Part of the arguments in our brief is that individuals have the full power to be able to decide how private or public their interactions want to be. If I have something to discuss that's of an intimate, close nature with my family, I might go to the back bench in a restaurant and talk in hushed tones, and that would be a private conversation in most states. But if I'm out here loudly talking about something illegal that I did and you happen to record it, that's not private. And he's picking up on that nature of individual agency. Individuals are perfectly capable of being able to decide how private or how public their conversation
has an interest in protecting the privacy of conversations, that everyone has some sort of right to the privacy of their conversations, full stop. Now, you can disagree with that as a matter of policy. But we've got to figure out why that's wrong as a matter of constitutional law for you to prevail.
Primarily, it amounts to the tailoring and overbreadth issue, Judge Celia. While there is a legitimate governmental interest in protecting conversational privacy, and 11 states have worked out tests to do that, on the other end of the constitutional equation is a right to be able to acquire information in public and report on that to the American people. So being able to record a bribe occurring with a police officer
But Massachusetts is talking not only about governmental privacy, they're talking about the privacy of all participants in these conversations, which typically take place between a government official and a private citizen.
Yes, and actually that's, as was noted by Judge Barron earlier, it is entirely capable that government officials and individuals are able to safeguard their own privacy. If they have a confidential conversation or an informant, they're able to meet in a private place. We are not alleging a right to be able to invade doctors' offices or police stations.
Yeah, but you are saying that if I think that I've taken precautions. I mean, I sometimes might sit on a bench in a park and speak in what I think is pretty confidential tones with someone else. And you're saying, but I'm at risk of somebody having a recording device that if I didn't notice it, that can then be sent all over the place, right?
I want you to note that even in his hypotheticals, Judge Barron sees himself sitting on a bench.
Duly noted, Your Honor.
So the limits of the law there, not just one-party consent, but when you're recording from a couple feet away. Talk a little bit about how they were testing the law.
Good judges ask questions that test the flexibility and the reach of a legal solution.
You're saying that if John Doe comes along, sees a police officer conversing with a politician, for example, they both have their backs turned to him. He holds out, in plain view of everybody, a tape recorder and turns it on, or cell phone, turns on the recording function. All right? They have their backs turned. But it's in plain view to anyone who wants to look. Everyone in the Boston Commons sees it, except maybe the two people who are talking. And you're saying that is or isn't a violation of the statute.
And so the judges were asking questions about whether could they set up a rule to prohibit recording or regulate recording in a courtroom? Well, of course they can, but it has to be very limited and narrowly drawn and tailored.
There's our opponent right there. Hello. Nice to see you. That's the Assistant Attorney General of Massachusetts.
And there was a question about conversations on a court bench. So I gave them a working theory. You know, if you were in Florida, for example, that has a two-party consent law, but you're allowed to record when it's not private. If you're there talking loudly, well, yeah, you're in a public area. If people are in earshot, yeah, you could record that. But if they were whispered, if they leaned in and whispered, and it wasn't audible without amplification, that would be deemed a private conversation. These are reasonable approaches to how a normal state, would balance privacy concerns and speech concerns. But we just don't have that here. You can't do anything in Massachusetts. And so the purpose of the lawsuit, of course, then, is not to offer some fine tinkering or offer some narrow construction or gloss that magically makes it constitutional, but is to send a message back to the Massachusetts legislature. Do what every other state has done and take the time to rewrite this and do the hard work. It's hard work to balance privacy and speech interests.
So the ACLU was a partner with us. How do I say it?
They filed a sister suit.
And the courtroom was filled with ACLU people. And what was she arguing on behalf of the ACLU?
The ACLU of Massachusetts argued that there was a First Amendment right only to record police officers doing their duties in public.
And we're more expansive than that.
Well, we think that you can capture malfeasance from tax assessors, town officials, teachers, anyone who's providing a public service should be subject to accountability by citizens. That was the purpose of me quoting Madison at the beginning of the argument.
In 1822, James Madison warned America that a popular government without popular information or the means of acquiring it was a prologue to a farce, a tragedy, or both. Today, nearly 200 years...
And he was in favor or opposed to surreptitious recording?
What are you asking the courts to do now?
We're asking that they facially invalidate the law, Section 99. Don't apply it just to Project Veritas. Don't create a complicated balancing test that rewrites the statute. Send it back to the legislature. Let them rewrite a law.
There's the ACLU people right there. I'm James O'Keefe.
Nice
to see you, Jesse. Thank you.
All right. Take care. We'll see what happens.